Hello, everyone. My name is Ryan Bordelin. I'm a partner at Stewart McDonald Stewart, and today I'm going to be talking to you about the delegation of board authority. It's a topic that comes up quite regularly for our clients, and so I just want to go over what can and can't be delegated, along with what typically is delegated, and some pitfalls to look out for when you are delegating authority. We're just going to give you a primer on delegation, but if you have any specific legal questions, you should always seek legal advice. This is just meant to be for informational purposes only. So here's just an overview of what I'm going to be speaking about today. I'm first going to be talking about the history of delegation provisions, just to give you some context, the current legislative provisions, some typical matters that are delegated by local governments, and then these pitfalls that I spoke about earlier. Now I'm just going to look at what the legislative landscape looked like prior to 1998. So at that time, there was really no ability for local governments to delegate. Basically, everything needed to be approved specifically by council for municipalities or by the board for a regional district. There were only certain very limited situations where delegation was permitted. This was for parks, recreation, and property management commissions only. Otherwise, municipalities had to rely on a specific section of the Municipal Act in force at the time that said that council has the power to do anything incidental or conducive to the exercise of the power. This was not ideal when a lot could be riding on whether or not something had been approved correctly or not. So why was there a change of approach in 1998? Well, this was around the time that the movement from specific authority of municipalities being the norm to more broad discretionary authority being the norm. And the lack of ability to delegate was considered an impediment to effective governance because everything had to be approved by the board or council. So a lot of their time would have been taken up by going through contract after contract, approving every single one. This was because only routine day-to-day contracts were within the authority of staff, like office supplies and that sort of thing. Everything else needed to be specifically approved. And this could also create hardship for anyone entering into a contract with a local government because any contract that wasn't specifically approved by a council or board was not enforceable. This is because a rule that typically applies to a corporation when you're entering into a corporation or a contract with a corporation doesn't apply to local governments. It's called the indoor management rule. So if you are to enter into an agreement with a contract to buy anything like even software or something like that, if you are dealing with a representative of that corporation, then you're entering into a binding agreement. But this rule, the indoor management rule, doesn't apply to local governments. So if it turns out you're entering into a contract with a local government and there was no specific resolution or bylaw authorizing that contract, your contract would not be enforceable. And there could potentially be a court battle to determine what rights the person did have in those situations. So for all of these reasons, there was a change of approach in 1998. So what is the current approach? Well, there's the same basic rule that everything that a municipality or a regional district does can only be done through a resolution or a bylaw. But there's now new provisions that allow council to delegate to certain groups of people. So these provisions are found from sections 154 to 156 of the community charter. I'm not going to put them up on a slide because I'm going to go through them in more detail than that would allow. So basically, municipalities can delegate to council members or a committee of council. They can delegate to officers and employees, and they can delegate to other bodies established by council, like a commission, but they can't delegate to a separate corporation that they've created. So the approach is to create a general authority saying that the powers and authority of municipalities can be delegated by council, but then there is a list of types of matters that cannot be delegated. So there's no list that says this is what you can delegate. It's the opposite approach. There's a general authority to delegate, and then a list of things that cannot be delegated. So I'm going to go through what can't be delegated very quickly and then give you more specific examples afterwards. So matters that cannot be delegated include the making of a bylaw, powers or duties exercisable only by bylaw, and powers of council to approve something or to consent to something, or to provide recommendations or acceptance of an action or a decision or another matter. Other things that cannot be delegated include the power to hear an appeal or to reconsider something, the power or duty to terminate the appointment of an officer, and the power or duty to impose a remedial action requirement. So you might be able to see a bit of a theme here in these items that cannot be delegated. They are either legislative actions or quasi-judicial actions. The reason for not being able to delegate these items is, I think, pretty clear. Council has been elected by the members of a community to act in its best interests, and what it sees are the values of the community. So that's generally reflected in bylaws. So in order for a local government council to be accountable, they have to be the ones making the decision. The same with these quasi-judicial decisions that I'll go into more detail regarding in a little bit here. So I'm not going to talk about the authority to pass a bylaw or exercising an authority that can only be done by bylaw, because those are pretty self-explanatory. I'm going to move to the third item on the list, which are the inability to delegate approvals, consents, and recommendations. So just to give you a bit of an example, and there are many more of these, for municipalities, the authority to consent to another municipality or regional district providing a service in that municipality cannot be delegated because Section 13 of the Community Charter uses the language of consent. So it falls within this category of things that cannot be delegated. For regional districts, an example is the acceptance of a regional context statement in an OCP in certain limited circumstances in Section 448 of the Local Government Act. So that acceptance of a regional context statement in an OCP has to be done by the board, cannot be done by anyone else. And now I spoke about earlier, reconsiderations cannot be delegated. So that's when a delegated authority makes a decision, but there's a right of reconsideration built into the legislation. That right of reconsideration cannot be delegated. So here on the slide are just a few examples. If this includes if authority has been delegated to issue a development permit, or to require development approval information, or to issue a temporary use permit. If council or board has delegated any of those, the reconsideration, the right of reconsideration that's built into the legislation has to go to council or the board. A couple of other examples are if a business license has been refused, there's a right of reconsideration built into Section 60 sub 5 of the Community Charter that has to be done by council, and the right of reconsideration for a remedial action order in Section 78 of the Community Charter. Moving on to the next item that cannot be delegated, that's the authority to terminate the appointment of an officer. Just as kind of a side note here, the legislation makes it clear that the board or council can still delegate the power or duty to appoint or to suspend officers, but only to the CAO. Now I'm going to talk a little bit about the delegation of council hearings, which is permitted. So I'm not going to go into any real detail because this could be the topic of a separate presentation, but I am going to just kind of go over the basics. So delegation of a hearing can only be to council members. Hearings can be delegated that are either required by law or authorized by an enactment. So if authorized by an enactment means that there's some sort of hearing built into a bylaw or a legislative provision, that can be delegated. Required by law means even if there's no procedure for a hearing for a matter that has a judicial kind of flavor to it, if required by the rules of procedural fairness, you can still delegate that hearing. Kind of as a subset of hearings that can be delegated, council can delegate hearings under which a person is entitled under the Community Charter to make representations to it. So an example of this is where a person is going to have their service cut off, for example, their water service cut off because they didn't pay their bills. Before the service is cut off, they have the opportunity to make representations to council. But because this is framed as making representations, those representations can be delegated to either a specific council member or a group of council members. But it's always important to remember that the delegation of an appeal or reconsideration cannot occur. If that's the type of decision, judicial decision that's being contemplated, if it's an appeal or a reconsideration, you cannot delegated. Now, just a little bit more about what you can and can't delegate, or how you can delegate in terms of hearings. You can either delegate a specific hearing by bylaw or a specific type of hearing by bylaw. So if there's ability under a property maintenance bylaw to have a hearing that's going to be delegated to a group of council members, either a specific one can be delegated or the whole type of hearings can be delegated. The legislation also draws a distinction between the hearing of a matter and the decision that follows as a result of that hearing. So either the hearing can be delegated or both can be delegated. So for example, it's similar to a public hearing for a zoning bylaw where a specific group of council members can hear the public hearing, but then they have to create a report that is presented to council as a whole, and then council as a whole makes the decision regarding a rezoning. So that's similar here. So if the hearing of the matter has been delegated, then it makes common sense that the decision can only be delegated to those same council members. But if the hearing of a matter has been delegated to a few council members, but council as a whole is to make the final decision, then there has to be a report made to council as a whole regarding what happened at that hearing. And just to be clear, you can also establish a right of reconsideration for any delegated hearing. So I've gone through what can be delegated, and I'm just going to pause briefly to speak specifically about regional districts, which are somewhat different in their delegated authority than municipalities, but not really that different. The only real difference is that if a regional district is going to delegate, then 2/3 of the votes cast have to be in favor of the delegation, unless you're delegating a hearing, in which case it's a simple majority. And if you're going to repeal the delegated authority, it's only a majority of the votes cast that are required. So why was there a change from the previous approach? Well, as we've already discussed, the previous approach was very cumbersome administratively for local governments. So this approach allows for a more efficient administration, but at the same time leaves council or the board responsible and held accountable for the important legislative and quasi-judicial decisions that it makes. So I'm going to move on now to what you often see delegated by local governments. So typically there'll be a delegation bylaw, and in that delegation bylaw, specific matters will be delegated. So we often see the authority to enter into contracts delegated up to a certain dollar amount, and that can vary quite significantly from municipality to municipality, often related to the size of the municipality and the number of contracts that they would have to approve. So larger municipalities tend to have more delegated to staff, with smaller municipalities not necessarily seeing the need for that. Often the authority to enter into agreements in relation to services and operating and enforcing a regulatory authority and management of property are delegated. For example, if you have like an animal control bylaw and you have to enter into an agreement with someone to run the pound, that sort of agreement can be delegated to staff because it's maybe not typically very controversial. Or the property management decisions, such as entering into a janitorial contract for your town hall, that can be delegated to staff. The authority to provide assistance, so to provide grants in certain circumstances, some municipalities will delegate this to staff or to certain council members. It's not that common, but it does occur. Other examples of matters that are typically delegated include the authority to obtain and dispose of property and personal property, etc. So the authority to sell land that's owned by the municipality up to maybe a certain value could be delegated, or the authority to enter into leases or licenses of property. So for example, if you have a recreation facility, you want to enter into licenses allowing people to use that property for different purposes, you can delegate that to staff. Often the procedure to follow for procurement is part of a delegation bylaw. They'll often say that up to a certain dollar value, there can be a sole source award, but above that, there has to be a competitive process. Often the ability to settle minor legal disputes will be delegated often to the CAO. And as I've already kind of spoken about the ability to enter into leases and licenses of local government property are typically the subject of the delegation bylaw. So now what are the pitfalls that can arise with delegation? Well, one is that delegation has to be done by bylaw, not by a resolution. So often you will see local governments have a procurement policy that's been approved by a resolution, and that procurement policy will say that the CAO can enter into purchases up to a certain amount. The corporate officer, the chief financial officer can enter into agreements up to a certain amount. But because it's attached to a resolution and not a bylaw, there could be some issues with whether that's a true delegation. Another issue that comes up is that even if a matter has been delegated to staff, all of the statutory requirements related to that matter still have to be followed. So for example, with a disposition of land, you still have to provide notice in accordance with the community charter or the local government prior to the disposition, even if you delegated that matter to a specific staff member. Two other issues that come up are that you cannot reserve discretion in a bylaw, and you cannot delegate regulatory authority as opposed to administrative authority. And I'm just going to go through a couple of cases to illustrate what I mean by those. So regarding reserving discretion, this case, Sun Oil Company and Verdun from the Supreme Court of Canada is often the case that's cited. It involves a building bylaw that stated that once an application was received and had been vetted by a building inspector, council could at its discretion grant or deny the permit. So the Supreme Court of Canada found that this was not proper. This was outside the municipality's authority, because basically what the city did was reserve its discretion. It said that it granted the authority of the building officer to make the decision, but ultimately reserved its own authority to kind of supersede the building inspector. And that is not permitted. If you're going to delegate your authority to somebody, you have to really delegate it. You can't just kind of go halfway. And this is another example of a similar problem. So this is a New Westminster and Davis Industries case, where a zoning bylaw gave council the ability to veto business license applications for certain types of businesses. The court found that that was not permitted because it, again, was not really delegating its authority through the bylaw. It wasn't really exercising its discretion. It was reserving an exercise of discretion to veto a decision that was made under the bylaw. Finally, I'm going to talk about the difference between delegating regulatory authority and delegating administrative authority. And this case here is a good example of that. This is called Barthrop and West Vancouver. It involved a building bylaw that stated a structure could not be altered without a permit from the director of operations. So it's a building bylaw. The authority to regulate building has to be done by bylaw. The bylaw did not specify any criteria for how the director of operations was supposed to exercise its discretion that had been granted under the building bylaw. And the court found that this was unlawful because it reserved this discretion to a staff member. Basically, what the court found was that council wasn't exercising its regulatory authority. It was just granting the right to the director of operations to exercise this authority on its behalf, and didn't place any parameters on how that could be exercised. So a good example of this are sprinkler restrictions under a water bylaw. If you have in a water bylaw statement saying that a director of operations can change sprinkling restrictions whenever they see fit, this is downloading the regulatory authority, which you cannot do. But if you place parameters around when the director of operations can change sprinkling restrictions and create different levels of sprinkling restrictions, then you're transforming it from a regulatory authority to just the exercise of an administrative authority under the bylaw. You are getting rid of that discretion, and you are basically just saying to that employee how they can proceed when different circumstances occur. So that's kind of the idea of changing things from delegating a regular authority, which you are not permitted to do, to delegating administrative authority, which is no problem. So today I've spoken to you about the history of delegation, the current legislative provisions that apply, typical matters to delegate, and potential issues with delegating authority. Of course, this is only the tip of the iceberg. And if you want to know any more information, feel free to visit our website where there's a lot more information about delegation. Also, you can give me a call or email me at rbordelin@sms.bc.ca. And my phone number is 250-380-7744. Thanks a lot for watching. This has been a presentation of Stewart McDonald Stewart.